So what do you do in case of an online fraud, especially if it is on a credit card? Now, there are two things that has to be taken care of, especially if it is a credit card fraud. First thing is that you make a complaint, an online complaint in the cybersecurity portal, and furthermore, you make a complaint before the local jurisdictional police. Now, you have to be safe to ensure that, and you have at the same time also have to prove the bona fide. And the other problem that you may face would be the problems from the bank who may call in for loan debts, trying to recover the outstanding amount, which you may not be liable for. Unfortunately, that is not how it is. As far as the bank record is concerned, it is your name under which the amount has been taken out, though it may have been an unauthorized transaction in the initial stage. Now, in these circumstances, the moment the FIR is registered as a fraud, now we have to ensure that this is intimated to the bank. However, since the credit card loans being unsecured loans, it may be forwarded to arbitration. Now, here the question is whether a matter of fraud, is arbitrable in nature or not. There are few things that cannot be arbitrable in nature, especially if an arbitration tribunal is constituted. There are few things that can be, few disputes that can be decided and that cannot be decided because the tribunal lacks jurisdiction and at the same time expertise to analyze these things. Therefore, as per several Supreme Court judgments, whenever there is a matter of crime, fraud involved, arbitration tribunal does not have the expertise to decide upon it. So our remedy lies when the arbitration tribunal is constituted. We may have to file a petition under section 12 and section 16 of the Arbitration Act, challenging the constitution of the arbitral tribunal and at the same time challenging its jurisdiction to decide upon a matter which cannot be arbitrated.